This class deals with the law of contract. It's part one of several parts which will become increasingly more sophisticated in our treatment of contract. Contract is an extremely important area of business life. It's the legal framework for a lot of transactions that occur in business. And it's important that we understand the nature of contract and how contract is implemented in practice and what are the prerequisites for a contract to come into existence. So this is part one. There are several parts, and in this one I just want to go across the very essentials. Now this is covered in other videos, but I want to just start at the beginning, part one, and run through this one. So we'll start with the definition of a contract, which is just simply a legally binding agreement. And for a contract to be valid, it must have several essential features. There must be an offer, for example, on the part of one of the parties to the contract. One of the sides, one of the people involved in the contract, one of the organizations, whatever. One of the parties, as we say, must make an offer. And the other party to the contract, it takes two, the other party must accept. And this must be a voluntary offer and acceptance. There's no force involved. There's no duress. This is simply an offer and an acceptance. And there must also be an intention to create a legal relationship. The setting in which the contract is agreed will suggest there was an intention to create a legal contract. Perhaps the wording or the behavior of the two parties suggested that there was an intention to create a legal relationship. So that if anything goes wrong with the contract, they may go to court and have a decision made as to who was right and who was wrong. Another part of contract is consideration. Now there will be a session on consideration, but for the moment both parties must stand to lose something if the contract fails. So if one of the parties does not live up to his or her word, that party must lose something, and that something is consideration. So in consideration of the contract coming into existence, both offer something which they stand to lose. Now if all of those are in place, there is a contract, and that contract is enforceable in law. Now here we are dealing with common law, and we're dealing with commercial law. So we're not dealing here with criminal law. This is civil law. It's an arrangement between two individuals. It is not does not apply from statutes of government. It doesn't apply to everybody in the country. The particular conditions of the contract. It just applies to the two parties in the contract. The general principles upon which the contract is based, offer, acceptance, intention, consideration, these are general, but this is between two parties to the contract. So if something goes wrong, it is those two parties who will have to sort it out in court. So it's not like criminal law. This is civil law. Now, the requirements for a valid contract. Well, the requirements are one of the parties must make an offer to the other party. That's quite obvious. If that doesn't happen, there is going to be no contract. So one of them must make an offer. The other party must accept the offer. Perhaps there's some negotiation between them about the offer. Perhaps they change the offer and so on. But once the final offer is made and the other party accepts it, then we have the basis at least for starting to look at it as a contract. Now the circumstances of the offer and acceptance must indicate that the parties intended to enter into a legal relationship. So that was the intention of both of them, to be bound by a legal contract. And the two parties must give consideration, some sort of benefit to the other. Now the conditions for a contract. Well, the parties involved in a contract are bound to honour its terms. They must try to honour the terms. They've agreed to the terms, so they must live up to that agreement. And where a party does not carry out the terms of the contract, then he or she is in breach of contract. And if one of them is in breach of contract, then there may be legal remedies. If one of them does not carry out his or her side of the contract, the other party may seek legal remedies. Now that introduces the conditions of a contract and looks at an overview of what a contract is. And that's all I want to do in this class. This is part 1. There will be other parts to come. In the meantime, thank you for watching.